Okay, time for a quick First Amendment speech checklist now that we have gone through substantive due process and equal protection. Here is, again, a quick checklist of issues, right? Subject matter that you should be really comfortable with at this point. And if you are, good. And if you're not, time to hit the books. Number one, speech that's not protected, right? When you're looking at a fact pattern where the government is messing around with people's speech, obviously if it's the federal government, the First Amendment applies to the federal government on its face. If it's a state government, the First Amendment applies through the 14th Amendment due process clause, right? So when you see that fact pattern, something the government's doing, messing around with people's speech, the first thing you need to check is the speech protected speech? This is not too hard because most speech is protected. Unless it is, you can rattle it off now, right? If it's incitement, fighting words, or obscenity. Now there are some other emerging areas of law, but I want you to know those three, right? And you need to know the elements of incitement, right? And most speech is not advocacy for people to do something illegal, so that usually you can get rid of pretty quickly, unless you see that in the fact pattern, in which case, right, that you're being tested on incitement. Most speech is not fighting words, because most of the time you're not in somebody's face trying to start a fight. You don't see that very often, right? And most speech is not obscene, because most of it does not rise to the level of being patently offensive or appealing to the prurient interest. In fact, most speech is not even sexual in nature. And if it's not sexual in nature, there's no obscenity issue at all. So you need to check for that, right? Bullet point number 2, time, place, manner restrictions. If it is protected speech, the government is still allowed to enforce reasonable time, place, and manner restrictions on protected speech. So there you need to know your elements of a valid, right, and what courts call reasonable time, place, manner restriction. With regard to both bullet points 2 and 3, I want to emphasize, because bullet point 3 is O'Brien and symbolic speech, how important it is for you to understand, right, and be able to apply the concept of content neutrality, right? If the government's moving speech around under a time, place, manner restriction, or if it's targeting conduct, right, in an O'Brien type of a case, it has to establish, first of all, that it was not concerned with the subject matter of the speech, right? Unconcerned with the subject matter of the speech, as the court puts it in O'Brien, means content neutral, right, as the court talks about in the time, place, manner cases. So if the government's moving stuff around, you know the elements of a time, place, manner test, right? First of all, you have to get through the content neutrality hurdle. After that, you apply sort of a means-ends test and look whether, right, the means are somewhat loosely, narrowly tailored toward the achievement of an important / significant / substantial government interest, right? And then finally, under a time, place, manner restriction, you would look for ample alternative channels, unless it's a porn shop being zoned to the edge of town, in which case reasonable alternative channels will do, and that means any place left in the jurisdiction. So all of that should be stuff that you're very comfortable with. You should also, at this point, understand that O'Brien is very similar, right? The symbolic speech test is very similar, assuming it is speech. Message intended, message received. The government can still go after the conduct, right? If it's unconcerned with the subject matter, again, if the means are more or less narrowly tailored, pretty closely tailored to achieving something that's important, and obviously whatever conduct is being regulated, right, by the government needs to be regulable by the government. If that's the federal government, that'd usually be under the Commerce Clause. If it's a state government, it would have to be a valid exercise of police power. So time, place, manner test and O'Brien are very similar. Moving along. I want you to be somewhat familiar with public forum analysis, right? Most of what we talked about involves speech in public forums. You just want to be aware, of course, that there are places that are not free speech zones, so to speak, right, where we don't expect people to be exercising their First Amendment rights. Places like airport terminals, right, governor's residence, legislative chambers, right, courtrooms, places in public universities, auditoriums, right, same for public schools, that those places may be open for speech, right, that would be called designated, right, when one of them is open, it's called a designated public forum. And in designated public forums, right, speech has to be allowed on a content neutral basis. In non-open forums, right, non-traditional forums that have not been designated as open, the government can enforce any reasonable restriction it wants, as long as it does so in a way that doesn't target somebody's viewpoint. So also be aware that courts at this point, the Supreme Court is unlikely to find any new types of forums to be traditionally open public forums. It has a pretty conservative, originalist view of what constitutes a traditional public forum. So remember the Hare Krishna case, right? You're not going to get a court to say that an airport is a public forum. Make sure you're comfortable with speech in public schools K through 12, right? You need to know Tinker when it is not school-sponsored speech, right? And Hazelwood when it is school-sponsored speech. If it is school-sponsored, you get a rational basis type test where it's okay as long as there's some legitimate pedagogical interest. If under Tinker, right, you get the Tinker test, which is you need a material and substantial disruption, right, either in discipline or of the proper functioning and operation of the school. Next bullet point I have here is the press and prior restraints. I've lumped them together because sometimes they go together. As to the press, the press does have a right to certain access to courtrooms and things, public places to see what the government's doing. Some bright line rules here. Number one, there is no such thing as a reporter's privilege, right? Please keep that in mind. If there was a reporter's privilege, we'd have to define what's a reporter. Court's not going to get into that. There's no such thing. So reporters have to answer subpoenas. Another sort of bright line rule here is on prior restraints. So you need to be comfortable with spotting a prior restraint, right? Either a request for enjoining publication of something or some kind of censorship going on, right, as a prior restraint. Prior restraints are presumed to be unconstitutional, and it is a heavy presumption to overcome. Compelled speech. Just know the same rules apply. The same rules apply to, right, punishing speech, right, when the government tries to force somebody to speak. And that is to say, right, strict scrutiny would apply. Remember the New Hampshire license plate case, live free or die. That's what we're talking about. You can't force somebody to speak unless your measure is narrowly tailored to a compelling interest. Next bullet point, something for you to be comfortable with, is the concept of overbreadth. And I didn't, this was probably the point of the term where we sort of cut off and stopped going to live classes. So we didn't really have time to talk about this too much, but I just want for you to think about it now. You see a lot of the speech tests involve some kind of requirement of careful tailoring, right? That even applies to obscenity, right? Where obscene material has to be specifically defined in a statute. Under both Time, Place, Manner and O'Brien, right, there has to be some careful tailoring of the law. It doesn't have to be quite narrowly tailored. And of course, if we get to strict scrutiny, then it really does have to be narrowly tailored. All of that relates to the idea of overbreadth, right? Courts don't like to see restrictions on speech that catch up, right, more speech, right, than is necessary. So again, there are a number of different circumstances, whether you're applying strict scrutiny, whether you're applying the obscenity test, whether you're applying Time, Place, Manner, O'Brien. If you're finding that there's a problem with the means, right, that the means do too much, right, they go too far, courts have a word for that, and it's called overbreadth. So I just want you to be comfortable with that term as well, especially before you go and sit for a bar exam. Finally, and boy, this should come as no surprise, right? Once you've run out of excuses, right, and there's nowhere else to go, you apply strict scrutiny. And as I've said now in a couple of videos, if you don't know how to apply strict scrutiny at this point, because we've got a world of hurt on the horizon. So obviously you need to know how to do that, right? If the state or the government has already failed all of the other tests, right, it is protected speech. It's not a reasonable time, place, manner restriction. It's not a reasonable O'Brien restriction, right? I mean, if we've already been through all that and you wind up with strict scrutiny, it's going to be a heck of a job, right, for the state to try to get past that. Because a court would likely have already concluded that there's no compelling interest and the means are not appropriately tailored. Again, you have to be, in all of constitutional law, right, from dormant commerce on, comfortable with the concept of strict scrutiny. So that's a quick First Amendment speech checklist. I'll do another one on religion, and then we'll be pretty much done, I think, with our checklists, and can spend the rest of our time in the next live session going over problems, right, to see how to apply this stuff. So be well, stay safe, and stay tuned.